Recording in progress.
A very good morning to all my dear students. I'm glad to read your beautiful morning wishes, and I hope you have been waiting for today's class. And I'm glad to know those who have written, ma'am, we have revised the 4-5 case laws that we have done in the previous class. So very well done. Good morning, Shambhavi, Ridhi, Saurav, Manisha, Miss Ganga KG. Good morning. Ajit, Dainesh, Koreddi, Dhairya, Jyoti, Hira, Himanik Divedi, a new student today. Good morning. Nikita, Nitika as well, Dainesh, Priyanka Jha, Sridhar Mayur, Vidhi Talat, Vidhi Jaspreet, Samyak Jain. So Samyak writes good morning 7-8 times. So good morning, Samyak Jain. Miss Barna, Mr. Abdul. Abdul is asking me questions about LLP. So let's be in Companies Act, Abdul. Maybe after we end the session, if you have any query, I'll be there to answer you. But as of now, we'll stick to Companies Act. Good morning, Mr. Sanket. Even I have been eagerly waiting to meet all of you. Miss Mansi Kumari. Dinesh, I hope you can see us now. Sumit, Madhi Shetty, Manoj. Miss Kirtana, Jyoti, Sarvesh, Abhinav, Balaji. All of you are very good morning, children. Mr. Karma, Vila, Balaji, Kushagar, Kashish, Akaran Jana, Chandan, Sujan. Wow, different names. Alok Singh. Good morning, children. Mr. Ankit as well. So as always, I hope you have revised and I've read, many of you have written also that we have gone through the provisions of first chapter and you have very well understood corporate veil. We have discussed what are the characteristics of companies. So as always, let's take a small quiz or a test of my students just to actually see whether they have remembered everything or not. So if I tell you that there was one case law, Salomon versus Salomon and Company Limited, can anyone tell me what was the major teaching of this leading case of Supreme Court judgment? What was the major conclusion taken out in Salomon versus Salomon and Company Limited? So my children knows now the definition of Companies Act. They know that company is a artificial person, invisible in the eyes of law, something which cannot be seen or touched, but yes, they have their individual identity, shareholders and company are different. But I want to know, definitely, Mr. Ankit Kumar Mishra, we will be doing the Companies Act amendments also, and that is something which I have a flavor for you all in today's lecture as well. So, but before that, I want you to answer me. Mr. Santosh Kumar, notes will be visible by end of the lecture today because we are still yet to complete the first part of the types of companies, and after that, I'll be uploading the notes. So please tell me, Salomon versus Salomon and Company Limited में हमने क्या conclude करा था? What is that leading case laws tells us about? Meanwhile, I'll just open the presentation for all of you. Yes. Excellent. Excellent. So let me tell you, there are many who have answered it correctly, and there are others who are in some another, sailing in some another land. Danish, definitely you can ask me the query related to sale of goods, but my first concern will be to finish off with Companies Act, and then maybe any other act queries you have, children, you may ask me, but that will be there for half an hour in the last lecture. So day after tomorrow, we are meeting for the last lecture. I know it's an emotional feeling because I also get attached with my students when I meet them. But day after tomorrow on Thursday, when we meet, last 20 minutes, we'll keep your query sessions. That time you can ask, okay? All right, Ms. Priyanka Jha, we'll understand about public and private companies, so your query will get answered there. So definitely correct, Ms. Manisha, Nafisa, Vidya, Mr. Abdul, all those who have written that it helps in knowing that the company has a separate legal identity. That's absolutely correct. Manisha, Aditya, Sinha, Karishma, Misha, Dinesh, Jyoti, Yatiraj, many of you have sent the correct answers. So wonderful. Omnath Dhakal, he's saying we came to know about secured creditors. Okay, that's correct. Salomon was getting the money because he was a secured creditor, not just because of the owner. But then, child, you have to tell me what concept got its identity. So those who have written corporate veil, Komlakshi, very good. Koreddi, Jaspreet, Sujal, that's absolutely correct. The meaning of corporate veil in itself means that there is a shield existing between the shareholders and the company, which helps us to identify that the company has a separate legal existence. So good morning, Ash Babu, Shibha Khan, Khushi, Alok, you all are also right. Definitely, Kushagar, Ganga, Deepshika, all of you. So separate legal entity, we have clearly understood. Jaspreet Kaur, when you tell me, ma'am, it is lifting of corporate veil. So those were the cases which we have discussed in where the corporate veil could be lifted. But Salomon versus Salomon and Company Limited is specific case of separate legal identity, which helps us to clearly mention that there is a veil which exists between the company and shareholders and they are different from each other. That was the reason payment was given to Salomon, because he was a secured creditor of the company. Great. Mr. Ankit Prasad, you are sailing somewhere else. You're asking about compensation by old lady. I did not understand your query. Definitely, Ms. Bhumika, that's absolutely correct. The answer that you have written for the secured creditor, that's correct. Ms. Shiba Khan has written another very interesting point. Shareholder cannot be held liable for the acts of company. Excellent. So when we go in the memorandum of association, we'll talk at length about which are the acts for which shareholders are not liable and what happens when the liability goes outside. So that is another topic. Mr. Jatin, if you're asking me about the identity of companies, it depends about the company and its shareholders are two different. Yes, that's absolutely correct. You have just mentioned that it has a separate legal entity, so it's fine. All right. Very good. Chandan, Vinita, Nikhil, Samir Singh, everyone has understood it nicely. Good. And I hope you all remember these lifting of corporate veil specific case laws also, and we don't have any specific queries in that as well. So what is the topic that we are going to start today? So today, children, we'll try it the way you have answered me right now. I was thinking, let's have some different way of a structure of class today. Let's try to make it a little more interactive. So we'll be having a discussion on classes of companies, which means types of companies. So I'll be teaching you, I'll be talking about the types of companies. At the same time, I'll be asking you questions about your understanding. So MCQs is a separate part. We have certain MCQs also, which we'll take up after doing public and private company. But in between, I want to make the session a little more interactive so that you're answering me back. And I want to know that how much you have understood as well. All right. Yes, we just did a quick revision. Saurabh Singh, you're asking me again to do a quick revision of Salomon versus Salomon. We just did that. No, Danish, we are meeting on Thursday as well. All right. So classes of companies, what we're going to understand, what are the types of companies today? So number one, it says on the basis of incorporation. Now, children, types of companies, if you'll see, we have huge types of companies: public company, private company, one-person company, holding company, subsidiary company, associate company. So there are many number of companies. And the interesting part is, examiner, I told you 13 marks question generally come from Companies Act. It can be 13, it can be 15. 13 to 15 tentatively we have to mark it. Okay. All right, children, now I'm not paying attention to the queries. Mr. Balaji, you're still asking queries. Please pay attention. We'll be covering all those holding, subsidiary, public and private. Everything will be covered in today's session. So just pay attention. Mr. Santosh Kumar, you as well. All right. No, you should, Ankit Prasad, I did not understand when you say wrong answer. So you pay attention and so that you'll be able to write the correct answers. All right. Now, on the basis of incorporation, so the first category of the companies, yes, I was telling you that examiner might not straight away give you a question that, okay, fine, please explain what a company limited by shares. He may give you, tell us the difference between company limited by shares and companies limited by guarantee. Now, how you have to answer, what you have to answer, we will never go outside the study material. Whatever is given in the study material has to be there in our tips. That all my students know by now. कि हमने study material को तो learn करना ही करना है. We have to eat it, we have to grab the information and we have to save it at our subconscious mind and we have to apply our knowledge at the time of examination. He might ask you such straightforward questions, or he might ask you that there is a person who has come from a foreign country. He stayed in India for a few days. Can he open an OPC? So for that, it is known as not exactly a case study based question, not a very descriptive question, but yes, a one-liner question. So instead of asking you directly what is an OPC, he can give you a twist. He can give you a story. He can give you a two-liner, say something related to a nominee of an OPC, something related to can a single person open an OPC. So for that, we have to remember all those 8 to 10 points given in the study material has to be on our tips. So that if the examiner asks us a question on any of the point related to that, we should be able to answer the entire concept based on the understanding of one-person company. So one-person company is very, very important concept, and there is a major amendment given in your RTPs, which occurred in last year, 2020 and 2021, November 21 examinations. That amendment was applied. So it's very, very important amendment. After that, no amendment has come up so far. So after doing one-person company, I'll take you to the amendments and I'll try to teach you. Because children, if straight away we'll go to the amendments, तो बोलोगे मैम ये क्या करा दिया आपने? कि कौन सी paid up share capital, who is turnover, what are you talking about? We don't know. So first we'll understand the concept, and this answer is for all those who are asking me, ma'am, we'll do amendments. Definitely we'll do amendments, but before doing the amendments, it's very important to do the basic concept. अगर मैंने ABCD नहीं कराया तो मैं कैसे बता दूं कि ABCD के बाद K आना है या E आना है? So we have to do the basics first, then we understand that where the change has come. We have to bring the change turn by turn, the step by step. We'll be learning how the amendment occurred and what happened, why was the reason, and this is where the changes came up. And then we will mark the amendments in our study material as well. So first category is very, very simple, on the basis of incorporation. What is the meaning of incorporation? Remember, when we get a self-registered, I told you last time also, when you get incorporated, you have registered companies, statutory companies, and chartered companies. Now, chartered companies are like East India companies, which were earlier existing. Registered companies means the companies, once you get yourself registered, companies, they have to get themselves registered with the ROC. There is an entire question that we'll be doing on the registration of companies, how the companies get registered, what is the application to be filed, within how much time the certificate of incorporation is given. So incorporate hona means company ka banna, incorporation ho jana, promoters are there, promoters file an application. After filing an application, they become the members. When they take up the shares, they become the shareholders. So entire story about registration of companies we'll be taking up in the next lecture. As of now, you should know that the companies after incorporation become registered companies. And these are the registered companies which are further divided into company on the basis of liability, on the basis of public and private companies. And statutory companies are those which are created by a special act. Like LIC Act creates LIC companies. Insurance companies are creating a different company. So different acts, they are governing different companies. Remember, I told you to the banking regulations, insurance companies, all these companies, Companies Act is also applicable, but only where there is a disagreement between the respective acts and Companies Act, then we try to follow the provisions of their respective acts. And chartered companies no longer exist, so we don't need to go into discussion about them. After that, a very, very important concept is known as companies limited by shares, companies limited by guarantee, and unlimited companies. Now, children, you remember why we shifted from partnership to LLP? Because in partnership, huge liability burden was there. As a sole proprietor, I was having unlimited liability, paisa dena padega, invest karna padega, to sir pe bojh tha. So I was having a lot of formalities of paying the liabilities off. So we thought, let's not form partnership, let's form LLP, limited liability partnership, so that my liability gets limited. All right. So Mr. MD Razak Ansari, it's absolutely fine if you'll go through the study material and you'll go through the notes and you can listen to the recorded lectures. Definitely you'll be able to pass. Okay, don't worry about that. Okay. Yes, Priyanka Jha, that's correct. So we have to understand that on the basis of liability, there are different types of companies. So our liability was huge in partnership and our liability was decreased. It became limited when we shifted to LLP, that is limited liability partnership. Now what happened after that? We thought that let's open a company Although LLP was giving us a corporate legal existence, it gave us a separate identity. You must have done an LLP also, we get a separate existence and partners are different. But in order to have a vast experience, in order to do a business on a much larger and broader scale, we think of forming a company. Now, another benefit of a company from partnership is that a liability is limited over here. 90% of the companies which are formed are companies limited by shares. And then we have a promotional companies or, companies which are taking their funds from donations, fees. Okay, they are doing this kind of companies are known as companies limited by guarantee. So we'll be taking up a very important case law also today from the study material for the companies limited by guarantee. What is the major privilege? What is the major benefit given to the companies limited by guarantee? That they are required to pay off the liabilities only and only at the time of winding up of the company. What is the meaning of winding up? Only when the company is getting closed. So companies limited by share, here the liability can be asked at any time during the lifetime of the company as well. But ma'am, this is fine. But what is company limited by shares? Ye to bataya hi nahi aapne. How do we know what is limited by shares and limited by guarantee? So here goes your answers for companies limited by shares. So let us take a very interesting example. So say, for example, Mr. A has taken up shares in a company. He taken shares in a company. 10,000 shares he has taken for rupees 10 each. So he has taken 10,000 shares. So Mr. A has taken 10,000 shares in a company of rupees 10 each. And at the time of making the payment, share application allotment happened. First call, second call was made. And we came to know that he has paid rupees 8 per share. Now, how much is the paid up capital? How much has he paid up in that? Yes, children, normal maths. Rupees 80,000 he has already paid. Now, how much is the unpaid share capital? What will be the unpaid share capital? 10,000 multiplied with 2. Is it okay? 20,000. So now law says in case of company limited by shares, pehli baat to shares means share capital will be involved. Members will be taking up shares in this company. They will be investing in this company. So liability, what is liability? How much you have to pay. So in partnership, the liability was unlimited. That means if the company has a liability of 1 lakh rupees, then even if you have contributed 10,000, even if you have contributed 15,000, you have to pay off 1 lakh rupees. Chahe aap ghar se property lao, whether you sell off your personal properties or whatever you are doing, you have to pay off 1 lakh rupees. But here, if the liability of company is 1 lakh rupees, for example, how much should I ask Mr. A to pay? It says Mr. A will be liable in case of company limited by shares. Mr. A will be liable only up till the amount unpaid on the shares. So he has already, it was a 10 rupees share. He has already paid 8 rupees. Now the liability which was pending was rupees 2 to be paid. So now whenever the liability will occur, whenever the shareholders will be required to pay off the liabilities, Mr. A can only be invited to pay off rupees 20,000. Understood? So paid up share capital, how much you have paid, we have nothing to do with that. In case of company limited by shares, we are concerned how much amount was left to be paid. So now if there is a problem in the company, the liabilities of the company are 1 lakh rupees, Mr. A will be liable only up till 20,000. इसको बोलते हैं लिमिटेड, लिमिट लगा देना. अनलिमिटेड लाइबिलिटी नहीं है. You are restricting yourself only till the amount which is unpaid of the share. So my rupees 2 were left to be paid. So you can call me anytime wherever the liability of the company arises. Mr. A will come and he will pay for the amount of rupees 2 per share. Clear हो गया सबको? Company limited by shares is clear. Those who are asking me the words you are picking up from the study material, be patient. Understand the definition first, then we'll be going to the study material and we'll read it from line to line over there. Okay, children? Now let's understand what is company limited by guarantee. So company limited by guarantee means, let's take another example. Mr. A said, I will contribute rupees 15,000. So he gives a guarantee. There was another person in the company, Mr. B says, I will pay rupees 25,000. Company went into liquidation. What is the meaning of liquidation? Company is now getting closed. And the liability of the company was, कितना करना है? 1 lakh? 1 lakh पे मैम को अच्छा लग रहा है. So liability of the company was rupees 1 lakh. So there were many shareholders in the company, many members of the company. So we have talked that it was a company limited by guarantee, and Mr. A has given a guarantee to the company that I will contribute rupees 15,000 towards the liabilities. And Mr. B has given a guarantee that I will contribute rupees 25,000. What does this mean? So if I say the company's liability is 1 lakh, can I ask A and B to pay me beyond this money? Ideally तो क्या होना चाहिए? कंपनी की liability 1 lakh है यार, पैसे तो देने ही पड़ेंगे, आप लोग शेयर होल्डर्स हो. Law says a special privilege, a special benefit has been given to the guarantee companies. Number one, they will be invited to pay off the liabilities only at the time of winding up of the company. Winding up को हम क्या बोलते हैं? Liquidation भी बोलते हैं. Liquidation means company close हो जाना, बंद हो जाना. So there was a company which they have opened up. Mr. A, B, and C, D have opened up a company. A and B has given a guarantee of 15,000 and 25,000 liability. Now, if the liability of the company is 1 lakh, Mr. A is required to pay only up till rupees 15,000. Mr. B will be called up to pay only up till rupees 25,000 because this is the maximum limit. So even after that 60,000 limit is left, we have to dispose of that liability from the company's asset. We will not request the shareholders to pay anything beyond the amount they have guaranteed. All right. So this is what you have to remember. This is what you have to learn. Now, when we go to the study material, the things will become much, much simpler. So in case of company limited by shares, answer me, what is the liability of the shareholder? Is it paid up share capital or the amount unpaid on the shares? Answer me, children. In case of company limited by shares, how much is the amount that we have to pay? Wow, students have already answered, ma'am, 20,000. Excellent. So Shivam Gupta, absolutely correct. Rupees 2 per share, which is unpaid on the shares, was the liability up till which they have to pay. Very nice. And in case of a company limited by guarantee, the amount which the shareholders have guaranteed, they have agreed to pay this much amount. That is the only amount for which they can be called upon to pay for that, and nothing they have to pay beyond this. Clear ho gaya? And what are unlimited companies? Unlimited companies means you have to tell me, children, if you, me, and others have opened, if all of us have opened an unlimited company, then if the liability of the company is rupees 1 lakh, how much we have to pay? Law says now your liability is unlimited. Pura ka pura 1 lakh, all the shareholders will have to pay. Even if required, your personal assets will be sold off in order to pay the liabilities of the company. Why? Because you have chosen to be a part of an unlimited company. So unlimited companies means the members have unlimited liability. Whatever is the liability of the company, the shareholders will be invited to pay it off. All right. Let's go to the study material and have it a fair reading from there as well. So good children, when you respond back, I really like that. So that means you're understanding it well. So this is your broader category of division about types of companies. Incorporated means those which are, somebody was asking me a difference between incorporation and unincorporated. Now you, me, A, B, C, and Harleen ma'am, 3 and 4 people, we thought that let's make a company. So when we met, we decided to meet at Cafe Coffee Days. So as I'm very fond of meeting my students on coffee, so we decided that A, B, C are my 3 students, and now they have become chartered accountants. So they said, Harleen ma'am, let's meet up and let's make a company. So we met for a meeting, on a coffee meeting, and we were discussing. We discussed about what business we have to do and what are the other things. But those stocks were only left till that coffee table. None of us ever went to get the company registered. So the companies which has a base, which has a purpose, we had a discussion, but we never got ourselves incorporated, means it never got registered are the unincorporated companies. Means something still needs to be done in order to incorporate a company, means we have to bring the company into existence. And companies come into existence only after getting a certificate of incorporation. When you apply to the registrar, you do all the formalities. So here, Mr. ABC and Harleen ma'am were just having a discussion on coffees, and we were having huge plans that we'll do this business, we'll do that, and we'll make up a company limited by shares, whether it will be a public or a private company. We were discussing about the number of members to be there. But वो सब बातें ना वहीं कॉफी टेबल पे ही रह गई, and nobody went to the registrar of companies, and we never got ourselves incorporated. So such kind of companies which are never incorporated are unincorporated companies. And when the companies get incorporated, registered with the registrar of companies, they get the symbol of certificate of incorporation. And further on the basis of incorporation, they are divided into registered, statutory, and chartered companies. Chartered companies no longer exist like East India companies. Statutory companies I've already explained you, like ICAI is a statutory body because it is governed by a ICAI Act. So these are body corporates having a special act which governs them. And registered companies is something which we are doing. Registered companies are further divided on the basis of liability. अब अगर आप बोलोगे मैम unlimited company is unincorporated, no, it is a company which is a registered company. So unlimited companies are also registered. Companies limited by shares are also registered. Companies limited by guarantee are also registered companies. So all these three are registered companies. It's just that on the basis of liability, we divide them in the further categories. Okay. And what happens after dividing them on the basis of shares? If the company has a share capital, then they are further divided into public and private companies. So all these companies limited by shares can either be a public company or it can be a private company. What is public company? What is private company? I'll teach you. But as of now, simply understand that the broad category is registered companies has three basic categories: limited by shares, by guarantee, and unlimited companies. Unlimited companies में हमारी liability unlimited होती है, हमें personal assets भी बेचने पड़े, then also we have to dispose of the liabilities of companies. But companies limited by shares, you all answered me correctly, ma'am, only till the unpaid amount of shares we are liable. And in case of guarantee, whatever amount I have guaranteed. So if ABC and Harleen ma'am got themselves registered, A said I'll pay 10,000, B said I'll pay 15,000, C says I'll pay 15,000, and I say I'll pay 5,000. So I gave them less guarantee. So now when the company is winding up, you cannot ask me to pay more than 5,000. I have agreed, I have guaranteed, then I will only pay 5,000, and others 10,000, 15,000, 15,000 respectively, they will be required to pay it off. Okay. So this is what we have already understood. Now, if you ask me, ma'am, where is this amount which is mentioned? So section 2, subsection 22, those who are asking, ma'am, we have to learn the sections again. The answer remains same. If you can learn, you should write these sections, but never write a wrong section. So what do we do if we don't want to write the section? As per the provisions of the Companies Act 2013. Simple. Obviously, those who have written a section has a more marks can be given to that person because it gives a good impression, but never write a wrong section. You should either avoid writing a section instead of that. It says the company, members of the company, the liability is limited by its memorandum of association. Now, what is memorandum of association? I told you there are very important documents of the companies, that is articles of association and memorandum of association. Here it is just telling you where this liability is defined. कहीं लिखोगे तो सही ना, अब ऐसे याद थोड़ी ना रहेगा ₹2 per share unpaid था या फिर ₹5 per share unpaid था. So you have to record it somewhere, you have to write it somewhere. So it says it defines that where the liability of the members is limited by its memorandum. So the liability will be written in the memorandum of association to the amount of the shares held by them, then it is known as company limited by shares. It implies means it means that for meeting the debts of the company, debts का मतलब क्या होता है? Liability. to pay off the liability, the shareholder will be called up only to pay the amount unpaid on his shareholding. तो यहाँ पे जो हमने अभी एग्जाम्पल करा था ₹20,000 वाला, वो आप लिख लेना. Please write down that example that we just did in my notes right now. So though a shareholder is a co-owner, he is not a co-owner of the company's assets. I told you, company's assets are different and shareholders' assets are different. Although you are a co-owner, although you are part of the company, but company will never ask you to dispose of your assets and pay off my liabilities. Ownership of the assets remain with the company because company is a legal person, so company has its own assets. The rights and duty of shareholder is measured by his shareholding. So if I am having 10% shareholding, I'm a 10% shareholder. If you are holding 50% shares in the company or 50% shareholders, so our rights and duties are defined on the basis of how much share I'm holding in the company. Now, company limited by guarantee also we have done. It is given under section 2, subsection 21 that your liability is limited. किसमें लिखा हुआ है? Memorandum में. तो यहाँ पे भी liability कहाँ defined है? It is written in the MOA of the company that the liability will be up till the amount you have agreed, undertaken to pay at the time of winding up. So I just now taught you that the liability that you have agreed to pay at the time of winding up of the company, that is the liability up till which you are limited. All right. It is limited up till the stipulated amount means agreed amount. Stipulated amount means agreed amount mentioned in the memorandum. Members cannot be called upon to contribute beyond that. So the example we just did, 15,000 and 25,000 example that we have done in the presentation, you can write down that example. So even if the liability of the company is 1 lakh, but you will be required to pay only 15,000 and we will only be paying 25K, not beyond that. Now comes your very, very important part. It says company limited by guarantee and company having a share capital are legal personalities and limited liability. इसका मतलब क्या हुआ? I want each one of you to pay full attention because it is a very important topic. You will understand if you'll not pay attention. Now it is saying common feature means what is the major point in both of them. So both of them have a very common feature that whether it is a guarantee company or the shareholding company, both of them, number one, has a legal personality and they have a limited liability. So what is the common points in both of them? Both of them has a legal corporate personality, which all of you told me Salomon versus Salomon has proved that point, that company is separate from its members. There is a veil that exists between the company. So you cannot say that it is only shareholding company which has a legal personality. Both the companies, guarantee company also and share capital company, both of them has a legal personality. And second benefit is both of their liability is limited. In the latter case, latter means baad wali, that means shareholding company. Here the liability is limited by the amount unpaid on the shares. Here you have to state the liability in the memorandum. In both the cases, I just told you that you have to mention your liabilities in the MOAs. So what are the two basic features? Common points. Common points means दोनों में same क्या है? दोनों की liability limited है and both the liabilities have to be written in the memorandum of the companies. Clear हो गया? Similarities, common points clear हो गए. अब differences देखते हैं. So it says there is a difference between both these companies. In the former case, what is the meaning of former case? Company limited by guarantee. The members required to discharge their liability only at the time of winding up and subject to certain conditions. But in case of the share capital companies, they can be called to do it during the lifetime of the company or during the winding up. What does it mean? So if if A, B, C and Harleen ma'am have formed up a company limited by guarantee and there is a liability of the company up till ₹1 lakh. Okay, we have formed up a company limited by guarantee and there is a liability 1 lakh and the company still continues. Kya bola maine? Company is not winding up and company is into continuation. Then can we ask Mr. A, B, C and Harleen ma'am to pay off ₹1 lakh? Yes or no? जल्दी बता दो मुझे. मैंने कहा there is a company limited by guarantee that we have formed up. No, Sumit, we have another session. Don't worry. Yes, Varun, that's absolutely correct. It's a statutory body. So please answer me, children. Can A, B, C and Harleen ma'am, who have formed a company limited by guarantee, can you ask me to pay the liability for 1 lakh rupees if the company is having a liability, although I gave a guarantee of rupees 5,000? So do I need to pay this liability during the lifetime of the company? If company is existing, company continues. I have still not received the answers. Yes or no? Can we invite the members to pay off the liability? Absolutely correct. Very nice. Priyanka, Kaushik, Misha, Vidya, Piyu, Sanket, Shambhabi, Harshika. Excellent children. That means you're paying concentration. Harshika Singla is saying, yes, ma'am. No, you are wrong. Even if you're saying, yes, ma'am, only till 5,000, then also you are wrong. Because Santosh Kumar, that's correct. So we have agreed. Okay. Misha Mehta, you are also incorrect. You are also saying only till the agreed amount. So the answer is wrong. Those who have said yes, the correct answer was no. Why no? Because I just told you that in case of company limited by guarantee, the liability of the members arises only at the time of winding up the company. So अगर company continue कर रही है तब आप members को नहीं invite कर सकते. Only when the company is winding up, it's getting closed, then only you can ask the members to pay their liabilities. And what happens in case of the company limited by shares? Then your 20,000 rupees that are required, anytime the company can ask you to pay off those 20,000. समझ आ गया? फटाफट से लिख लो पहला पॉइंट ऑफ डिफरेंस. द फर्स्ट पॉइंट ऑफ डिफरेंस इज कंपनी लिमिटेड बाय गारंटी. Company limited by guarantee, comma, the members are required to pay the liability only at the time of winding up. The members are required to pay the liability only at the time of winding up. However, in case of company limited by shares, in case of company limited by shares, the members can be invited to pay the liabilities anytime during the lifetime of the company or during the winding up. एनी टाइम ड्यूरिंग द लाइफ टाइम, मतलब जब तक कंपनी चल रही है तब भी बोल सकते हैं, और या फिर वाइंडिंग अप के टाइम, दोनों तरफ कभी भी बोल सकते हैं. Now it is clear from the definition of guarantee company that it does not raise its working capital fund from its members. Now you will ask me, ma'am, then how are we running the company limited by guarantees? This A, B and C and Harleen, ma'am, they have formed a company limited by guarantee. So we have formed ABC Limited. Now we are running this company limited by guarantee, but how are we running it? You told us that we are not even giving a share capital. We are not even raising the initial working funds. So working funds, working capital कहाँ से आएगी? वो कहता है, these companies will get their working funds from endowments, fees, charges, donations. So children, company limited by guarantees are generally a charitable kind of companies where we are not, that's why we are limiting ourselves. No, we don't know how much business, how well we will be running the company. So we open a company limited by guarantee. So we will say that, okay, ABC, we have decided to open a company limited by guarantee. Now, how will we run the company? Where will we raise the money from? We will give advertisements for such company. People will give donations, fees or charges will be given, and we will use those capital for the business purpose, for the motive for which we have opened. So these are basically company limited by guarantees are very few. They are not on the commercial basis. So you write it down. Companies limited by guarantee are not on the trading or commercial basis. They are most likely on the charitable kind of side. So here we raise our working capital funds from the donations, subscriptions or fees, whatever we get, and we try to use that money for that respective purpose. Now, what happened in this particular case law? All the eyes and ears here, please. It says in Narinder Kumar Agarwal versus Saroj Mallu, the Supreme Court said that the rights of guarantee company to refuse to accept the transfer by a member of his interest is on different footing than the company limited by shares. Why? Because guarantee company members may carry privileges. कह रहा है company limited by guarantee enjoy number of benefits as compared to company limited by shares. तो अभी मैंने आपको बता दिया एक बेनिफिट हमारे पास क्या था, अभी आपने मुझे बताया ना, नहीं मैम हम आपको नहीं इनवाइट करेंगे, व्हाई, बिकॉज ड्यूरिंग द लाइफ टाइम ऑफ द कंपनी वी विल नॉट आस्क यू टू पे ऑफ द लायबिलिटीज ऑफ द कंपनी. So you all understood one major advantage is that company limited by shares, you can ask any time Mr. A to come and pay 20,000. But in case of company limited by guarantee, you will not ask A to come and give 10,000 unless and until you're winding up the company. Clear ho gaya. Now what happened in Narinder Kumar versus Saroj Mallu case was that when the company went into liquidation, it was a company which was having share capital as well as guarantee. तो ऐसी कंपनीज भी होती हैं जहां पे दोनों चीजें, तो they were having guarantee was also given by few guarantors. So let's assume Mr. C and D has given a guarantee and there were shareholders Mr. A and B. Let's assume it. I'm just taking an example, okay? So when the company went to a liquidation and they have to pay, say, 11 lakh rupees was the liability of the company. Just example, 11 lakh rupees. And there was some amount which was unpaid on the shares. Now, what will happen if there are shareholders, share capital also and guarantors also, then we will try to use both the liabilities, right? Although they are company limited by shares and company limited by guarantee also. Both the cases were involved in this Narinder Kumar Agarwal versus Saroj Mallu. So what happened when 11 lakh were to be paid off, the company called the shareholders first to pay off the amount unpaid on the shares. So all the shareholders, let's assume there were 3,000 shareholders. So it was a public limited company and there were 3,000 shareholders and all of them had an unpaid share capital of rupees. How much you want? Okay, okay, let's take 10. Let's try to complete it. There were the shareholders, say 3,000 shareholders, and the unpaid amount was that much that all of the shareholders, when they paid, 11 lakhs got paid off. So you can just do a working. Let's assume, let's make it 30. If we say 30,000 shareholders, let's keep the liability only limited. Wait, let's do it once again. So the liability of the company to be paid off was, let's assume, rupees 1 lakh. And there were 3,000 shareholders who had the unpaid liabilities of rupees 10. Okay. So there was 30,000 amount that was to be paid by the unpaid share capital. So the shareholders will pay and balance 70,000. Whatever the guarantee was given by Mr. C and D, they will pay. Samajh aaya? First, we will call the shareholders. They will pay the amount. 30,000 they paid because their unpaid share capital we are assuming was rupees 10 per share. So 30,000 they paid and the balance 70,000 was paid by Mr. C and D. Now let's assume another example. Let's assume another example that if the entire shareholders, when their money was called upon, it became rupees 1 lakh. It became rupees 1 lakh. So let's assume that the entire unpaid share capital amount was 1 lakh rupees and the entire shareholders were asked, now tell me one thing, if 1 lakh was the liability of the company to be paid up and the shareholders are paying on the unpaid amount shares, that is rupees 1 lakh, will you call the guarantors also to pay for that? So in this respective case, Narinder Kumar Agarwal, what happened was the share liability of the company was paid off by calling on the amount which was unpaid on the shares. So if it was 1 lakh rupees, when we called the shareholders, the unpaid amounts was, let's assume it became rupees 2 lakh. So when we already getting 2 lakhs, so we will say, okay, pay 1 lakh and 1 lakh will return to the shareholders. Do you need to call the guarantors now? The answer is no, you will not be calling the guarantees because company ki to liability pay off ho gayi. So since you have already paid the liability by the shareholders calling the money, so guarantors got very angry. They said, what is this? Oh, sorry. Guarantors were very happy because they do not have to pay this. And shareholders got very angry. They said, you have asked us to come and pay the amount unpaid on the shares, right? And we paid you the amount and you dispose of the liabilities of rupees 1 lakh. But why you did not call Mr. C and D? So law said, Supreme Court held that rights of the guarantee company have a different footing. Guarantee company people will be invited only and only if still the liabilities are left. If you are disposing of the liabilities by inviting the shareholders for their unpaid amount, you will not bother the guarantors. So that is the kind of benefit which the company's limited by guarantee enjoys. So you can simply remember, you don't have to remember the entire story of examples that we have shared. You simply have to remember, children, number one, company limited by guarantee has a different privilege. That is, they have a benefit. They are invited to pay off the liabilities only at the time of winding up. If in case of winding up, the shareholders have only paid up the liability, then they may not even be called to pay off the amount. Clear hai? So this is known as company limited by shares and guarantee. Let's move to the unlimited company. Now all the students already know, if your liability extends to whole of the company's debts, and still you can claim the contribution from other members. So if the liability is so huge that company's assets are not able to pay it off, then we might ask the shareholders also to come forward and personally make the payments. Where the amount is stated. So we learned in case of company limited by shares and company limited by guarantee, memorandum में हमने amount लिखी है. Where have we written the amount? In the memorandum of association. Unlimited companies, your articles of association will state the amount of share capital. So here, articles of association. Which articles? Not the articles which come in newspapers and magazines, but articles of association is another important document of the company. So articles of association will define how much amount of share capital and the amount of each share shall be written in the articles of the company. Creditors can file a proceedings for winding up for their claims and the official liquidator कौन होता है? जब company winding up में जाती है, then company appoints an official liquidator who will dispose of the assets of the company and pay off the liabilities. So he will call the members for their contribution towards the liabilities and debts, which may be unlimited. Unlimited means their personal assets can also be used. So just write down, unlimited means personal assets can also be utilized in order to pay the liabilities. Clear ho gaya? So let's take a small break over here and then we will be starting with a very important concept, that is OPC. Let's take a small break. Are we connected? Because I can't see the response. I was just trying to read it. All right. All right. Thank you so much. Thank you. Thank you. Will you mute yourself? Thank you. Thank you. Yeah, welcome back, students. I have gone through your queries, and trust me, I'm going to answer only the relevant queries. So many irrelevant questions also come up, children, when you study Companies Act. So we will be paying attention. First of all, we only have to do the things which are given in a study material. So Companies Act is very, very huge. How you change your liabilities also come up when you do the alteration in your articles and memorandums. So that is entirely a part of CA Inter. And after CA Inter, CA panel will also be giving you a flavor of law a lot. So we have to go step by step. Number one, restrict yourselves to the study material. That's it. Along with that, the amendments that have come. Shiba Khan, definitely it is updated. You can follow the material which we are discussing, whether it is in the class or it is my notes. Everything is highly updated. You can follow it. You don't need to refer to any other books. All right. Now I will be taking up all those queries which you have sent me, the relevant ones. Okay. Thank you, Vinita and Jyoti, for confirming. Priyanka Jha, your general questions that you have written about the nominee we'll take at the end. Shivam Chaudhary. So definitely that example that you have shared, 80,000 was paid and 20,000 is the balance liability that needs to be paid. You will be only called for that unpaid amount. That is absolutely correct. Palak Gupta is writing about Contract Act. Remind me in the last lecture day after tomorrow. I'll guide you how you have to prepare for that. Don't worry. Hemang Divedi, OPC is different from sole proprietor. Hanji, 100% OPC is different from sole proprietor. This is the topic which we are going to start with. Bhumika, liquidators are the persons who are appointed by the court in case the company goes into official liquidation. Company is getting winding up. So we have to appoint the liquidator. Like in case of insolvency, you remember, official assignee was appointed. Similarly, a liquidator is appointed for the company who will take care and dispose of the assets and pay off the liabilities. Misha Mehta, that is company's headache. How will they finally dispose of the liabilities? What we have to remember is in case of company limited by shares. So if you have paid up shares for rupees 8 per share and rupees 2 were left, you will, as a shareholder, will only be invited to pay that unpaid share capital. How the company is managing the balance things, you don't need to worry about that. As of now, we simply have to concentrate on the, in case of guarantee, is the amount that you have guaranteed, you will be paying up till that. In case of shareholding, only till the amount unpaid on the shares. And somebody was asking me, same goes for you, Mansi Kumari. I hope this answers your question as well. And Mr. Abdul, definitely we can have companies limited by shares and share capital together as well. OPC Dinesh, we are just going to discuss. NPO is also Mayur, it will be coming up. Again, Sanket is stuck between incorporated, corporated. So just pay attention what is part of your syllabus. We are not talking about unincorporated companies. Incorporated companies are further divided into different categories. Aditya Sinha, you have written out such a big piece. Write your queries in short so that we don't waste much time in reading. So that's absolutely correct. In case of companies limited by guarantee, only at the time of winding up, we can ask you. Otherwise, during lifetime, we will not be asking you in case of guarantee company. Now, children, I'll be not looking into the queries in between. We'll just take the queries at the end because we have to complete very, very important concepts. And OPC is something which is new for all of you. So let's pay attention. OPC, that is one person company. Number one point, you all must write down that it is not a sole proprietorship. Please, those who are asking 8-9 people have asked, ma'am, is it a sole proprietor? No. It's not a sole proprietorship. Here we are talking about the one person company, a single person who is going to form a company. Now, what happened in Companies Act 2013? A new category of company came up, that is OPC. OPC means one person company. So you can see this man having the specs and wearing the suit boot and carrying a suitcase. And he's so excited and happy that, wow, 2013 amendment has given me a right to open up a company alone as well. So earlier, what was the case? Actually, children, in case of a private company, what is the minimum number of members required in private company? 2. What is the minimum number of members required in case of a public company? It is 7. So if I had to form a company, I could either form a private company or a public company. So private company was better because if you want to set up a business all alone and you just have to set up a company, you will request a friend of yours or maybe any relative of yours, please join hands with me because alone I cannot set up a company. So you are forcing someone to please join with you so that at least private limited company can be set up. Or you have to go and request 7 members so that we can open up public company. So government thought there are many individuals, entrepreneurs single-handedly who want to do the business, but they can't get the structure of company because in an individual, you're always a sole proprietor. आप अपना business कर रहे हैं, company एक organization चला रहे हैं, so you're a sole proprietor, but if you want to get major benefits of limited liability, corporate existence, then you cannot set up a company till 2013. You were not allowed. So government thought, let's give a privilege to encourage the entrepreneurship and corporatization of business. Let's encourage people to set up a company at a larger scale. A single person was also allowed to set up a company. So it says 1% company is a person which has only one person as a member. If I ask you how many members, minimum number of members required for setting up an OPC, please tell me. What is the minimum number of members required for setting up an OPC? Arbas, okay, that was correct. Definitely, Kashish, if guarantor dies, his legal representatives would need to pay the amount. Mayur Gupta, these all are the registered companies, child. Companies limited by shares, companies limited by guarantee, and unlimited companies. Pushpa is asking difference between the companies limited and unlimited companies. Why don't you tell me? Unlimited companies means personal assets can also be used to pay off the liabilities of the company. And limited means एक limit लगा दी है, restriction लगा दी है, या तो guarantee के amount पे या फिर share capital unpaid amount जितना भी रह गया उस पे आपकी restriction है. Unlimited में no limit. You have to pay off the company's debts. Okay, now how many of you have answered me? Oh my God. Aditya Sinha, you are giving me 7 members in case of OPC. I have asked you how many members, minimum members required to set up an OPC. Children, I hope you're answering me this one. Excellent. Yes, ma'am. Obviously, 1%. Good, good, good. It's a private company which has minimum 1%. So OPC mein minimum number of members required is 1. Maximum number of members required 1 because it's 1% company. So 200, 7 unlimited wali limits. I'm glad you all remember from your business studies in class 11, 12 that you have studied public and private company. That is absolutely correct. Alfia, I hope now you can hear us clearly because others are answering very nicely. So I hope the voice is clear, children. Single person, Pragati Patel, is enough to set up an OPC. Absolutely correct. So 1%, basically, children, you have to understand that to encourage the entrepreneurship means the government wanted that the people should come forward and they should get the legal existence kind of structure. Therefore, it was given an opportunity that a single person can also set up an OPC. Now, what happens when you set up an OPC? Let me just clear it and let us just make the points, notes in our study material. Number 1, OPC is different from sole proprietor. Sole proprietor अलग होता है, OPC एक company होती है. Number 2, OPC gets a separate legal existence. You all know now, company is different, shareholders are different. तो OPC company को भी एक separate corporate legal existence मिल जाती है. Whereas in case of sole proprietor, your liability is not restricted. Here you get limited liability. Point number 3. So liability of OPC is unlimited? No, it's a limited liability of the member. So company, you can just set up a company. It is a kind of a private company, private limited company, and your liability is also limited. OPC is not setting up public company. You're setting up a private limited company. The only thing is after the word private limited, you have to use the word OPC after your name because you're a single person. Private company में 2 बंदे थे. अब मुझे दूसरा बंदा नहीं मिल रहा पर बिजनेस करना है भाई एंड बिजनेस लार्ज स्केल पे करना है, लायबिलिटी भी लिमिटेड चाहिए, तो चलो बैग उठाओ और एक ओपीसी सेट कर लेते हैं. सिंपल ओपन 1% कंपनी. सो व्हाट विल आई गेट? I'll get separate legal existence. Number 2, I'll get limited liability. That means my liability is not restricted. It extends to the in case of sole proprietor, your liability is not restricted to it extends to the owner's entire assets. So official and personal. So children, those who were asking unlimited liability, यहाँ पे clearly बताया हुआ है कि आपके official assets and personal assets दोनों को यूज करा जा सकता है कंपनी के लायबिलिटी डेट्स की भरपाई करने के लिए. अब इससे ज्यादा हिंदी नहीं बता सकती मैं, समझ आ गया होगा. So limited means only to the extent of your share in the business. Unlimited means to the personal extent you have to pay the liabilities. Point number 4, the procedural requirements of OPC are simplified through certain exemptions given. So it says it's very easy to set up an OPC. Otherwise, to set up a private limited or public limited company, huge formalities needs to be fulfilled. So in comparison to other forms like Section 8 companies, central government approval is required. Huge formalities are required to fulfill. So as far as OPC is concerned, it's not that complicated. So he's giving you there certain points that you need to remember and certain exemptions are given and the procedures are very simplified. And point number 5, children, you should mark that OPC is a private limited company. So if I ask you, if I'm a single person, can I set up a public company? So your answer will be, no ma'am, you cannot set up a public company. So one person can never set up a public company. But can one person set up a private company? Yes ma'am, one person can set up a private limited company, that is OPC. And if you are 2 members, anyways, you can set up a private limited company. So it says OPC is a private limited company with minimum paid up share capital as may be prescribed and at least 1 member. So ma'am, what is this minimum paid up share capital? This is something which bothers my students a lot because law mein ye sabse interesting line hai, as may be prescribed. So where it is prescribed? So children, Companies Act, I told you earlier also what happens in case of companies. Depending upon the advancement of business, government keep changing the rules and regulations related to the companies. So depending upon the economy, how the economy is doing, government sets up the limit, the minimum paid up share capital, which is required for setting up a private company, for public company. So whatever is the limit which is prescribed during for that particular year, you should follow that particular limit. Okay, as of now, there is no limit that is written over here. It says that whatever is the share capital limit prescribed, you have to follow the Companies Act rules, whatever amendments keep coming, you have to follow up that minimum paid up share capital. All right. And how many members? At least 1 member. क्योंकि 2 members तो वैसे ही private limited setup कर लेंगे ना, तो here OPC is a 1-person company. So let us understand the significant points. How many members? You have all answered me. Yes, ma'am, correctly. Only 1 person, maximum 1, minimum 1. So 1 person can set up a company. What is the minimum paid up capital? No limit has been prescribed. तो कह रहे जितनी prescribe करेगा उतनी होनी चाहिए, but अभी कितनी prescribed है? No limit. तो कर लो 10 लाख से कर लो, 5 लाख से कर लो, जितनी है आपके पास पैसे उतने से आप पेड अप शेयर कैपिटल 5,000 से भी कर सकते हो, 5 लाख से भी कर सकते हो. So it entirely depends upon you because no limit is prescribed. Memorandum of OPC will indicate the name of the other person. This third point is very, very interesting. First ho gaya, second ho gaya, third point talks about the nominee. Children, who is a nominee? Do you know? Can you tell me who is a nominee? So in case the person who is doing a business, if that person dies, then the entire business is given to the nominee. So if I am doing a business and I name in my will or papers that Mr. A should be given the business after I die. So when my death will happen, then Mr. A will get the entire business or entire things or entire profits or whatever the things are from that business. So that is known as nominee. So after the death of a person who take care of that particular thing is known as nominee. So it says now 1 person is the single person who is doing the business. So who will take care after his death or his incapacity? Say, for example, there was Mr. A who was doing a business and he became of unsound mind, incapacity to contract. Go back to your Contract Act, competency of person. Can a person of unsound mind do a business? The answer is no, ma'am. He cannot do a business because उसका दिमाग ही नहीं चलता तो वो business कैसे करेगा? तो बेटा फिर Mr. A का business किसको दें? तो वो कह रहा है कि आपका जो memorandum है, MOA है, it should mention the name of the person who shall become the member of this company if this Mr. A dies or if this person becomes incapacity to contract. So third point के आगे लिख लेना, name of the nominee is must. So if the examiner asks you, is it important to have a nominee in case of OPC? What will be your answer? You will say, yes, definitely. It is important to mention the nominee. Where it should be mentioned? The MOA, Memorandum of Association of one person company, shall tell the name of the other person, that in case of the death or in case of a death or incapacity to contract, that person will become the member of the company. Santosh Kumar, definitely, if that one person dies, company will continue. Who will take care of this company? That is Mr. Nominee, who is named over here. Yes, Varun, that's correct. Okay. Samyak Jain, that's absolutely correct. Okay. Somebody is asking about conversions of OPC. Okay, Aditya Sinha, that's correct. Good. अच्छा पहले जिस पॉइंट पे है नॉमिनी वो सुन लो, कन्वर्जन कैसे होनी है उस पे बाद में आएगी, पॉइंट बाय पॉइंट विल मूव. ओके ओके, मेमोरेंडम विल इंडिकेट नॉमिनी. क्लियर हो गया सबको कौन होता है नॉमिनी और क्यों जरूरत है. पॉइंट नंबर 4, द अदर पर्सन. हु इज दिस अदर पर्सन? यस करेक्ट, द अदर पर्सन इज दिस नॉमिनी. This nominee whose name is given should give his prior written consent in the prescribed form, and the same shall be filed with the registrar of companies at the time of incorporation. At the time of incorporation means at the time of setting up of the company. Now, ध्यान से सुनो. Listen to the example. Now, this Mr. A, who was setting up an OPC, he said, okay, I want to name Mr. B as a nominee. So what will he do? He will open up his memorandum of the companies and he will write in that memorandum that whenever I die or if I become incompetent to contract, then Mr. B will become the member. यही करेगा? ठीक है, यही करेगा. तो बेटा Mr. B को बताओगे नहीं, उससे तो पूछ लो कि तू नॉमिनी बनना चाहता है या नहीं. The law says not just you have to go and ask Mr. B, you should take a written consent from this Mr. B and also file this consent with registrar of companies. So what this Mr. B will do, Mr. B, whose name is given in the memorandum, will sign a written consent. Okay, fine, Mr. A, I agree to become a member of your OPC whenever you die, and that paper has to be filed with the registrar of companies. Such other person may be given the right to withdraw his consent. थोड़े टाइम बाद मिस्टर बी को पता लगा यार मिस्टर ए मुझे इतना अच्छा नहीं लग रहा, आई एम नॉट वेरी फॉन्ड ऑफ दिस पर्सन, आई डोंट वांट टू बी अ नॉमिनी इन योर कंपनी. सो कैन ही डू सो? Law says he have the right to withdraw his consent. Whenever he wants, he can go to the registrar of companies and he can do the formalities by withdrawing his consent. So children, point number 3, 4 and 5 relates to your nominee. Okay, and member of OPC may at any time, point number 5 and 6 also, may at any time change the name of such other person by giving notice to the company, and the company shall intimate the same to the registrar. Point number 3 में हमने क्या पढ़ा? That Mr. B can also withdraw his consent. Clear है? Member of OPC may at any time change the name. Mr. A can also change the name. Mr. A को लगा मुझे Mr. B पसंद नहीं आ रहा, so he will send a notice to the company and will intimate the registrar that now I want Mr. C to be my nominee. So number 1, nominee has to be named. Number 2, file the nominee with the registrar of companies. Number 3, nominee can withdraw his consent. Number 4, OPC member can change the name of nominee also. Why he is changing, what happened, don't go into that. Simply learn what Mr. A OPC has the right to do. Okay, so if he's not very happy or whatever is the reason, he feels that now I want somebody else to be my nominee, so he can think he can change the name of such other person. By हो सकता है Mr. B himself is not competent to do the business. हो सकता है Mr. A had 2 sons, Mr. B and C, and he's not having cordial relationship with Mr. B, so he thought I will make my second son the nominee. So by giving a notice to the company, and company shall intimate the same to the registrar. Any such change in the name shall not deem to be an alteration in the memorandum. So it says it doesn't mean that your memorandum needs to be amended. you can still continue with the same MOA. Alteration means changes. वो कहते हैं मेमोरेंडम में changes करने की जरूरत नहीं, आप simply ये change registrar के साथ जाकर register कराओ. Obviously, you have to get the name changed with the official documents on the official documents as well. Clear हो गया? First 2 points are clear. Minimum paid up capital and 1%. Point number 3, 4, 5, 6, 7 relates to nominee. लिखते जाना. Now comes your very, very interesting story. Point number, how many we have done? 1, 2, 3, 4, 5, 6, 7. Point number 8 is the most interesting point and one of my favorites. So again, all the eyes and ears here. It says only a natural person. पहली बात उसने बोली only a natural person. दूसरी बात उसने बोली only an Indian citizen. And क्या बोल दिया? Resident in India can form an OPC or can be a nominee for the sole member of OPC. Now children, who is a natural person? You, me, your parents, everybody are natural person, natural living being. Is company a natural person? Yes or no? Jaldi bata do mujhe. Is company a natural person? Is company a natural person? Children, you are sending me queries related to OPC. I would appreciate if you pay attention, listen it carefully, then ask. Okay? Yes, Shiba, obviously I told you OPC is a private limited itself. Is company a natural person? Yes or no? Okay, I'm very surprised those who are saying yes. मुझे नहीं पता था company natural person है, खाना भी खाती है, चलती भी है, रोटी सब्जी भी खाती है. So ma'am taught you that company is different. It is an artificial person, something which is existing only in the eyes of law. Natural person nahi hai bachcha company. Very good, those who have written, ma'am, company is an artificial person. Nikita, why did you say yes? I'm surprised. Okay. All of you, those who have written, no, that's absolutely correct. I'm glad, MD Razak, it's clear, crystal clear to you. Thank you, Nikhil, Hira. I'm glad all of you are paying good attention and you're understanding. For use, Manisha, Dainesh, Ruchi, Saurabh Singh, Shivam, very good, excellent children. Digambar Sahu, Vinita, Santosh Kumar, great. So we all know that company is an artificial person. So number 1 point is clear, only a natural person can open an OPC. A company can never open an OPC. लिख के रख लो ये सारे पॉइंट्स. नेचुरल पर्सन को हमने डिफाइन तो कर दिया, बट इसमें हमने क्या सिग्निफिकेंट एनालिसिस निकाला? Mark an asterisk in your study material and write, a company cannot open an OPC. Only an individual can open an OPC. What kind of individual? Now, again, a question for you. I told you I'm going to make it interactive. I'm not going to teach you. I'm going to ask you. So there is my friend, Miss A, who is a resident of America. So I have a foreigner friend, USA mein rehti hai, and she is a foreign citizen. She came to visit me in my, maybe say, winter holidays. It was too cold in USA, so she thought I'll pay a visit to India. So she stayed in India for me for 196 days. Out of 365 days in a year, she stayed with me for 196 days. Although she is from USA, but she stayed in India for 196 days. Can my friend Miss A open an OPC in India? Yes, ma'am, or no, ma'am? Foreigner hai, meri friend Miss A, USA se aayi hai. I'm so happy that she has come and she stayed with me, and I told her about the provisions of Companies Act and taught her about OPC. She got so excited. She said, I want to open an OPC. So my CA Foundation students, my future chartered accountants are going to tell me that can this Miss A open an OPC in India? Yes, children, your study material is saying correct for 120 days. Let me complete it. Aditya Sinha says, people who can breathe are natural person, company cannot breathe. Interesting. Thank you, Abdul and Pushpa, for giving a correct answer. Dinesh, Misha, Abhi Gupta, Shambhabi, Samyak Jain. Samyak Jain, keep writing his name only. Good, Samyak Jain. Your answers are reaching to me. It's correct. Khushi, Kirtana, Yavar Alam, Vidhi, Ajit, all of you are correct, children. No, she cannot open a company even if she stays in India for 196 days. The major provision is she has to be an Indian citizen. I told you she's a foreigner. She's coming from USA. She's a foreign citizen. She's a citizen of states. No, she cannot open an OPC even if she's fulfilling the provisions of 196 days. That is actually, it is 120 days. Don't crib, children. I know your book says 120 days because that is the updated study material. I will be showing this 122 days to all of you in the amendments right now. So I told you when I started the topic, first you will pay attention, then only you'll understand. If you keep on discussing, ma'am, what is the amendment, you'll never understand. So pay attention, I'll teach you the amendments also. अगर मैं अभी 120 days बताऊंगी बच्चा, फिर इंडियन सिटीजन का पॉइंट रह जाएगा ना, पहले वो समझ लो. ओके, सो इंडियन सिटीजन क्लियर हो गया. फॉरेन सिटीजन इंडिया में आकर 196 डेज रह रहा है, 182 डेज रह रहा है, 125 डेज रह रहा है, तब भी वो नहीं खोल सकता बिकॉज इंडियन सिटीजन होना चाहिए. Now he is talking about the person who has stayed in India for more than 120 days. That's absolutely correct. The provision which is mentioned over here in your study material is correct because it is the amendment which has recently come that the person should have stayed in India for at least 120 days in order to call himself a resident in India. Where it is written, ma'am, let me show you the RTP's amendments where it has come, because many of you at times have the older study material also. So we have to make the changes in that particular study material as well. So it is clearly written over here, children. So only a natural person? Yes, ma'am. We just did that. An Indian citizen? Yes, that is also correct. Indian citizen. A person who is resident in India? Yes, resident in India. But this is what we call new provision. So there was an amendment which happened for November 21 examinations, and same is applicable for May 2022 as well. 2022 May में भी यही amendment applicable होगी. And the study material which is for October 2020 needs to have these following amendments. So if the website one we are using, it is for the 2021, but then we have the amendments also in our hand, so don't worry. So it says earlier the number of days that we had to see were 182 days, but now it has changed and said that person who has stayed in India for at least 120 days, he is eligible to open an OPC. आगे खुश हो गए, 120 days दिख गए आप लोगों को. अब ध्यान से मेरा क्वेश्चन सुनो. There was Mr. A. So my friend USA returned foreign citizen. You all agreed, no ma'am, not an Indian citizen cannot open an OPC. So another friend of mine, Mr. A, who is an Indian citizen, okay, who is an Indian citizen, went to Europe last year and returned India in January 2022. So now, can he open an OPC? Yes or no? Jaldi batao mujhe. He returned in India on 1st Jan 2022. He went to Europe last year, or precise kar dete hain, in August 2021. One of my friend, Mr. A, who is an Indian citizen, went to Europe last year in August 2021, and he returned back to India on 1st January 2022. Can he open an OPC in 2022 year? That is the immediately preceding year, means the year in which is preceding the financial year, means if I'm opening the OPC in April 2022, then I have to see the financial year from 1st April 2021 till 31st March 2022. So you simply tell me whether he can open an OPC or not. He went to Europe last year in August 2021. So what you need to count? You have to check that from April 2021 till July, he was in India. Yes or no? Yes, he was in India. From Jan 2022 till March 2022, he's in India. Yes, he's in India. Is he in India for more than 120 days? Yes, ma'am. So answer is yes, he can open an OPC in 2022 year. Because in the year preceding the financial year, whether a resident in India and otherwise has stayed in India for period not less than 120 days. So we have to count the period of 120 days, not the period of 182 days. So if he stayed in India, he's an Indian citizen during the immediately preceding year means एक साल पहले वाला. So then 2022 may definitely he can open an OPC because he is fulfilling these conditions. And shall be a nominee for the sole member. And this Mr. A can also become a nominee in another OPC only if he fulfills the same two conditions. So these conditions are not just for the member of an OPC, but also the same conditions needs to be seen for the nominee of OPC. Okay. It's just that the time doesn't permit. Otherwise, children, we could have taken so many examples and make it more interactive. But I am so much enjoying with all of you because you're answering me. Definitely Samyak Jain, he should be an Indian resident. That's correct. Natural person staying in India for more than 120 days. That's correct. Aditya Sinha, Bhumika, Nikhil, all of you. Nikhil Hirap, you're correct. All right. So 120 days condition has to be seen. So if Mr. A is fulfilling 120 days, then he can open an OPC. Otherwise, he will not be eligible to open an OPC. Similarly is the condition for the nominee. Okay. So now, children, another amendment that came for conversion of OPC. So whatever conversion was earlier happening. So पहला बता देती हूँ पहले क्या था और अब क्या हो गया है. So OPC cannot convert itself into any kind of company. Earlier, this was the earlier provision. Earlier means पहले ये था 2021 के एग्जाम्स के बाद 30th April में amendment आई. So earlier what happened that if 2 years have expired, you cannot convert yourself. So there was a condition that for 2 years, OPC cannot convert itself into a public company or a private company. Number one thing, except where the share capital. So there was a condition that if your share capital increases beyond 50 lakhs or the average turnover, not the profits. He's talking about the turnover. So if the turnover of the company exceeds 2 crore rupees or their share capital has increased beyond 50 lakh, then they were required to convert themselves into public company or a private company. Now, if you'll ask me why this happened, although from 1st April 21, they have omitted this. Now, law says OPC's conversion into public and private company has been removed. Law is silent on this conversion as of now. So earlier, why they had this law was, they were saying that you're setting up an OPC. Now, if your share capital has increased beyond 50 lakhs, so your turnover is increasing more than say 2 crore rupees, exceeding 2 crore rupees. So if you're having a turnover of 5 crore and your share capital has now become 70 lakhs, so law says you cannot be simply an OPC, single person company, or because a lot of compliance is required, for public and private company. So now a little bit more compliance work you should do. Otherwise, you can either convert yourself into a public company or a private company, but now you cannot be an OPC. But however, from 1st April 2021, they have simply removed this conversion. Clear ho gaya? These are the other amendments for your listed companies and small companies. After we have done about them, then we will come and jump to this. Okay. Small companies definition has also changed. So I've not taught you that. So when I teach you, you just have to change in your study material if you have an older one, that the paid up share capital and turnover of small company shall not exceed for more than 2 crore rupees and 20 crore rupees. Now this is small companies is the higher limit which is given. So where it is written as may be prescribed, this is just the higher limit which they have amended and changed. Earlier it was not given anything. It was silent on the higher limits. Now the clauses under clause 85, they had just updated and changed the higher limits. Clear ho gaya? OPC ki amendments zyada zaruri thi and we have almost done it. Now let's go and see if there's still any point left in the OPC, because I don't want you to leave a single point from your study material. All right, children. So it's clear now. We have erased this 120 days. No person is eligible to incorporate more than one OPC or become a nominee in more than one such company. So can you open 3 to 4 OPCs? Yes or no? The answer is no. Only one OPC. Can you be a nominee in more than one OPC? No. So you can only open one OPC and you can only be a nominee in one OPC. Likh lo. Can minor be a member or nominee of OPC? The answer is no. So straight away no for minor and straight away no for more than one OPC. So more than one OPC is also not allowed. Minor is not allowed to be a member or nominee, and neither he can hold a share with beneficial interest. Such companies cannot, अब ये सारे नेगेटिव वाले पॉइंट्स हैं, नो वाले पॉइंट्स ऐसे करने, याद करने के लिए हम ऐसे कर सकते हैं. पहले वाले 5 पॉइंट्स हमारे नॉमिनी के थे, फिर हमारी नेचुरल पर्सन एंड डेफिनेशन थी कि इंडिविजुअल कौन ओपीसी चला सकता है. अब हम एग्जेम्पशंस कर रहे हैं, अब हम नेगेटिव पॉइंट्स कर रहे हैं, वेयर इट इज नॉट समथिंग विच इज नॉट अलाउड इन ओपीसी. So it cannot be number 1. You cannot have more than one OPC. Number 2, minor is not allowed. Number 3, OPC cannot be converted into Section 8 companies. So Section 8 companies are very, very important. They are the charitable kind of institutions. Earlier, under Companies Act 1956, it were known as Section 25 companies. Now 2013 has given it the name of Section 8 companies. But if you ask me, ma'am, can we open an OPC for a charitable kind of purpose? So the answer is no. OPC cannot be incorporated or converted into Section 8 companies. You cannot have a charitable or promotion kind of art kind of work. Section 8 companies जो काम करती हैं वो नहीं हो सकती. OPC should be for a commercial and trading purposes only. Such company cannot carry out the non-banking financial investment activities also. So where the companies are investing into other securities, you have, instead of banking, you have non-banking financial institutions related to your investment and securities. So can you open an OPC for doing such kind of investments? The answer is no. And this is the point which talks about your conversion, which has been specifically omitted. मतलब इसको काट दिया गया है. Law is now silent on the conversion part. And let's see the last point. If one person company or any other officer contravenes the provisions, what is the meaning of contravenes? That means if they don't follow the provisions, they try to do any mistakes, then they shall be punishable with a fine which may extend up till 10,000 rupees. What will happen? The fine will be 10,000 rupees. And with a further fine which may extend to 1,000 rupees for every day after first during which this contravention continues. So let's take an example that Mr. B, who was a nominee in my OPC, मैंने बताया था ना आपको, Mr. A ने एक nominee बनाया, Mr. B, who was a nominee in the OPC, that is, the name of my OPC was A Private Limited OPC. So this Mr. B was a nominee in my company. Now Mr. B has become a nominee in C Private Limited OPC. So can you be a nominee in more than one OPC? So your answer is no, ma'am. You just now taught us that you cannot be a nominee or you cannot be a member in more than one OPC. So law says if any such kind of contravention, मतलब अगर आप कोई भी ऐसा गलत काम करते हो जहां आपको लिखा है कि आप नहीं कर सकते, या फिर जैसे अगर आपको बताया है कि OPC cannot carry a non-banking financial institution, but you try to be very smart person, you opened up an OPC and now you're doing non-banking financial investment activities also. Law says wherever you are contravening these provisions, a fine will be charged up till rupees 10,000, and a further fine of rupees 1,000 can also be extended for every day during which the default continues. So he'll come to you, he'll tell you that you're doing a contravention, you should not do it, 10,000 का fine भर दो, and जब तक आप ये गलती चलाते रहोगे, contravention continue करती रहेगी, each day के लिए 1,000 fine और पड़ता रहेगा. समझ आ गया children? Clear है? OPC is very, very interesting. If you do it with a nice, happy mindset, you enjoy doing it. If you'll do it as a burden and liability, then you know the consequences. So you have to be very happy about whatever you're studying. So see, study material has given you such a beautiful summary. One member company, private in nature, it encourages the entrepreneurship. Procedural requirements are very simple. Exemptions are given, separate legal entity and a limited liability concept. I hope OPC is absolutely clear. Still, if you have doubts, I'll take after 1 p.m., not right now. Now, private limited company से पहले हम करेंगे public company. So there are two different kind of companies. We have a private company and we have a public company also. So let me tell you why I jumped to public company in this. What is the meaning of public company? Another very, very interesting topic. So these three we'll take up in today's class: small company, public and private companies. So what is a public company? It says public company की बड़ी मजेदार definition है. A company which is not a private company. So it says public company is a company other than a private company. So that's why it becomes important to understand first what is a private company. So one member opening a private company, ma'am, now we know that one person is an OPC, but private company होता क्या है? Second, आपने बता दिया public company, any company other than private company is a public company. So now it becomes important to understand what is actually a private company. So number one thing, private company under section 2 subclause 68 they have defined. You don't need to learn the sections. If you can learn, write the right section, never write the wrong section. It is a company having a minimum paid up share capital as may be prescribed, and it shall restrict the right to transfer the shares. It shall restrict the number of members to 200. Now, what is he telling you? Let's make our own bullet points. Private company. How many number of members required? Minimum number of members? 2. Maximum number of members? 200. Can we transfer the shares easily? He says private limited company. You and me, we just met and we formed a private limited company. Now he says restriction. We can restrict each other from transferring the shares. So there is a certain restriction can be imposed on I can tell Mr. B that you cannot transfer your shares unless and until certain conditions are fulfilled. Not prohibition. I'm not stopping you forever, but I am restricting. Restrict कर देना मतलब कुछ certain conditions लगा दूं. So private limited company में we can restrict our rights on transferring the shares. We can impose certain restrictions, certain conditions to be fulfilled before you transfer your share to the another person. Because it's a closed netted company, it's private limited company. You cannot just get up and transfer your shares to any other person. So there is not a no prohibition, but certain restrictions can be attached on transferring of these shares. Clear ho gaya? This much points everybody know, minimum 2, maximum 200. So if I say that I want to set up a private limited company, so ABC decided to open a private limited company. So what is the name of a private company? The private limited company always have the words PVT Limited behind its name. PVT Limited behind its name. And what does public company has? Public company simply uses the words limited behind its name. Okay. Now let us understand there is a company ABC Private Limited Company and you decided to use and we formed a company, minimum 2 members were there. So ABC Private Limited was having, so we opened up a company ABC Private Limited and we were 10 members. खोल सकते हैं private limited company? अब ध्यान से सुनो. Yes ma'am, 2 members minimum चाहिए. So if there are 10 members, we can open a private company. And this ABC Private Limited doing the business with 10 members, and after 5 years, our number of members became 5,000. Can we have a private limited company with 5,000 members? Yes or no? फटाफट से बताओ मुझे. Can a private limited company, we were doing very good business and we opened up the company. Yes, ma'am, we can open up a company with 10 members. That's absolutely correct. Balakrishna, it's given under the RTPs. When you open the revision test papers, you will get the amendments. Okay, Khushi Bakshi, all of you will get it from there. If you want, I will show you the link as well. No, Ruchi Bajaj, I told you OPCs, you cannot be a member of more than one OPC and you cannot be a nominee in more than one OPC. Good, Nikhil. Vanshika, it means investing in different kind of securities and OPC cannot do that. Vanshika, it's given under your revision test papers. We will be taking up the another OPCs also, another amendments also. Okay, very good. All of you have answered me. No, ma'am, that's not done. Riddhi, you are the only one saying yes. That's wrong, bacha. No, it cannot done because maximum number of members in private company can only be 200. If you're extending a number of members beyond 200, you must convert yourself into a public company. समझ गए? Now, who are the members? He says, how do you count this persons whom you are calling for the number of members? Number one, it says 2 or more persons holding 1 or more shares in a company shall be treated as a single member. So for these 200 limit of members, if Mr. A and B are jointly holding certain shares, then it says the joint shareholders will be regarded as a single member. So 50% shares उसने hold करे, 50% उसने अगर ले लिया एक share में से, if 2 and more persons hold 1 or more shares in a company jointly. So simply you can write down the joint shareholders will be regarded as a one member. Okay, लिख लेना इसको, joint shareholders will be regarded as a one member. And the persons who are in the employment of the company, now this is very interesting. अब वो excluded बता रहा है, किस किस को आपने exclude करना है. People who will not be included in the number of members. Number one, persons who are in the employment of the company. तो obviously company के employees तो नहीं आते ना. अगर एबीसी प्राइवेट लिमिटेड कंपनी है और आपने मुझे अभी बोला कि मैम 5000 मेंबर्स, नो दिस इज नॉट डन, मिनिमम मैक्सिमम नंबर ऑफ मेंबर्स शुड बी 200 ओनली. बट अगर एबीसी प्राइवेट लिमिटेड कंपनी है विद 10 मेंबर्स और मे बी 199 मेंबर्स एंड दे हैव 5000 एम्प्लॉइज, देन लॉ सेज देयर इज नो प्रॉब्लम. एम्प्लॉयमेंट ऑफ द कंपनी को हम काउंट नहीं करते. Clear हो गया? We don't count the people who are the employees of the company. They're not counted as the members. And the persons who were formerly in the employment and now the members, and also while in the employment and continue to the employment after the employment ceased. He says whether you were an employee today or even if you were my employee earlier and now you have become a member, then also you are not counted in the number of members. So sometimes, you know, when you employ somebody in your company and you give them certain times, you give them the shares in the company. So if you were in my employment and now you have become members, so if you continue to be my members after the employment also, then also you will not be counted in the number of it. So जो भी employee है ना, चाहे आप लिख लीजिए past employee, present employee, both the employees are excluded from the list of number of members. So employees are not counted in the 200 wali restriction limit. We have a very important question, examination question, which we'll do on the basis of this employment also. So don't worry. And last point is it prohibits any invitation to the public to subscribe for the shares. अब इसको simple language में लिख दो, private company cannot invite the application from the public. अरे अगर मैंने public से पैसा invite कर लिया, shares invite कर लिया, फिर तो मैं public limited बन गई ना. So private limited, ABC and me, we are only the 4 members who are running a private limited company. So we will be raising the entire money out of ourselves only. So that means prohibit means we are not allowed. You cannot invite the public to invest in your company. Okay, clear है? Because once you invite the public subscriptions, then it becomes a public company. So no minimum paid up capital. So number one point क्या था? Having a paid up capital as may be prescribed. Ma'am, कितना prescribed है? Government will let you know whenever it prescribed. Right now there is no minimum paid up capital. तो आप 5 लाख से भी खोल सकते हैं, 50 लाख से भी खोल सकते हैं. It's absolutely your choice. Minimum number 2 OPC में 1 है. Maximum 200. Exclude your present employees and members and erstwhile means old employee का members also. So 200 में आपने employees को तो गिनना ही नहीं है, present employees को भी नहीं गिनना और जो पहले employees थे आज members बन गए उनको भी नहीं गिनते. Can I transfer my shares in private company? No, there are restrictions. Can I invite the public to invest in my company? No, there is a prohibition. Last 2 points. Small company is a private company. OPC is a private company. So listen carefully. आपका टेस्ट है. ABC, Mr. A is an OPC, wants to open an OPC and he wants to open a public company. Can Mr. A open a public OPC? The answer is no, because OPC can only be formed as a private company. ABC wants to open up a small company. What is small company? This is small company. Can they open a public company? The answer is no. Small company is always a private company. OPC is always a private company. तो हमने कितनी कंपनीज के बारे में आज पढ़ लिया? हमने रजिस्टर्ड कंपनीज देख ली, कंपनीज लिमिटेड बाय शेयर्स कर लिया, लिमिटेड बाय गारंटी कर लिया, अनलिमिटेड कंपनीज आर दोज यू हैव टू ब्रिंग द एसेट्स फ्रॉम होम आल्सो टू पे ऑफ द लायबिलिटीज. क्लियर हो गया? नरेंद्र कुमार वाला केस वी हैव लर्न. After that, we have discussed the huge concept of 1% company. So that 1% company is always a private limited company. What is private limited company? Number of members की restrictions है 202 है. Right to transfer of shares restricted है, and there is prohibition on inviting the public for the company. What are the last few points? Small company is always a private company and OPC is always a private company. That's it. Learn it. Now, what is small company? Those who are asking, ma'am, होती क्या है small company? तो ये रहा, small company is defined under section 2 subsection 85. It says it's a company other than public company. तो वो तो हमें पता ही है, private company है. Small company is always private limited company. So if you're opening a small company, always use ABC private limited company. You will never have ABC limited company as a small company. It always have to be a private limited company. Now, what is a small company? The companies where the paid up share capital does not exceed 50 lakh rupees or such higher amount as may be prescribed, which shall not be more than 10 crore. Now, अभी मैं आपको अमेंडमेंट दिखा रही थी ना, ये वो हायर लिमिट के अमेंडमेंट्स है. 10 करोड़ एंड 100 करोड़ को रिप्लेस कर वो लेटेस्ट अमेंडमेंट है. बट हमने लर्न क्या करना है? पेड अप शेयर कैपिटल shall not exceed 50 lakh rupees. Number one. And means both the conditions needs to be seen. And the turnover as per the profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees. So children, simple baat hai. If your paid up share capital is up till rupees 50 lakh rupees and your turnover is up till rupees 2 crores, then you are a small company. Simple. So if I ask you that ABC Private Limited has opened up a company with paid up share capital of 30 lakh rupees and their turnover for the immediately preceding year is 1 crore. So can you say it's a small company? Can I open a public company with these limits? फटाफट से बताओ मुझे. If my paid up share capital is 30 lakh rupees and the average turnover is 1 crore rupees, can I open a public company? Yes or no? All those who have answered the previous one's questions, that's absolutely correct. Now send me an answer for this one. So if I have a minimum paid up share capital, which is not exceeding 50 lakh, that is I'm having 30 lakhs and my average turnover is 1 crore. So can I set up a public company? Yes or no, children? I will show you the link of RTPs. Don't worry at all. Somebody saying, yes, ma'am, you can open an OPC. Okay. I'm asking, can I open? Am I on the other page? Okay. No, it will be a private company. Okay. No, ma'am. Yes, ma'am. No, ma'am. If turnover exceeds, you're not giving me the correct answer. Goodwill के basis पे कर सकते हैं. Abhi Gupta, where are you roaming? I'm asking you about small. Definitely, Nikhil. That's absolutely correct. Vanshika, correct. Yes, we can only have a private limited company. I hope you're answering me this one and we are not getting it confused. Dipanshi Agarwal, correct. No, ma'am, we cannot open a public company. Why? The answer is because it's a small company. So if you have 50 lakhs limit and turnover is below 2 crore rupees, then the company that you open up is a small company, and small company always has to be a private limited company. It can never be a public company. Another thing, so दो limits learn होगी आपको, 50 lakh rupees and 2 crore rupees. Those who want to see the RTPs, let them first show the RTPs. Okay, now you have to tell me if you can see this site, RTPs. So children, can you see this ICAI website, November 21, revision test papers, where it is written? When you go to this ICAI.org post, you have to simply find out where it is written revision test papers. You open up this November 2021 and it will take you to this. Are you able to see it? Okay. So now let's do the definition of small company. Section 285. What is the amendment which has come? It says the higher paid up capital and turnover. Where I was showing you that 10 crore rupees, na, it has just exceeded that the upper limits have been revised. They have revised the upper limits that should not exceed 2 crore rupees and 20 crores. So what is this 2 crores and 20 crores? This is what they're talking about here, 2 crores and 20 crores. You simply have to read this point. So these limits of 10 crores is now 2 crores and this 100 crores is 20 crores. Something which is not very important to learn because these are the higher limits. What you have to learn is paid up share capital shall not be more than 50 lakh rupees or such higher amount which has been prescribed. Itna learn kar lo bas, or the amount which has been prescribed. That's it. And the turnover shall not be more than 2 crore rupees or such higher amount as may be prescribed. Right now it is prescribed as 20 crore. And you have already agreed it cannot be a public company. It has to be a private limited company. Now, listen carefully. Can a small company be a holding or subsidiary company? No, ma'am. Small company cannot be a holding and subsidiary. Can a small company be Section 8 company? No, ma'am. Small company can never be a Section 8 company. Can never be a company or body corporate governed by any special act. So can ICAI be which is governed by a special act? Can it be a small company? No. So the companies which are registered under Companies Act 2013, the small companies is applicable to this paid up share capital and turnover limit. And further it says the exceptions. So small company cannot be a holding or subsidiary company. It cannot be Section 8 companies and it cannot be a company governed by any special act. Section 8 companies मैंने अभी आपको कराई नहीं है, but मैंने एक जगह पे और नाम लिया था. Name the companies which cannot be Section 8 companies. Quickly. This is your test. So which is the companies which cannot be Section 8 companies? So number 1, OPC cannot have a Section 8 companies. And number 2, we learned small companies cannot be registered at Section 8 companies. What are Section 8 companies? In the next chapter, we are going to do it. But आज हमने कितना लर्न कर लिया कि ओपीसी भी सेक्शन 8 नहीं हो सकती, मतलब चैरिटेबल इंस्टीट्यूशन नहीं हो सकता, स्मॉल कंपनी भी सेक्शन 8 कंपनीज नहीं हो सकती है. एंड व्हाट इज अ पब्लिक कंपनी? सो ये आपका ब्रीफ में उसने दिया हुआ है आपको सिग्निफिकेंट पॉइंट्स. स्टडी मटेरियल, यू नो, इट हैज सच अ नाइस kind of structure they have formed. They have given you briefing all the points. You don't even need to make the points. The flowcharts are there already in your books. Public company, number 1, ma'am, it is a company which is not a private company. What is private company? You've already learned. And no limit of paid up share capital. The paid up share capital as may be prescribed. तो जब गवर्नमेंट प्रिस्क्राइब करेगी तो उतनी हम कैपिटल रख लेंगे. सिर्फ इसमें एक ही इंपॉर्टेंट पॉइंट है बताने वाला. अ कंपनी विच इज अ सब्सिडरी ऑफ अ कंपनी नॉट बीइंग अ प्राइवेट कंपनी शैल डीम टू बी अ पब्लिक कंपनी इवन इफ सच सब्सिडरी कंपनी कंटिन्यूज टू बी अ प्राइवेट कंपनी. वेरी वेरी इंपॉर्टेंट पॉइंट. 2 मिनट में समझ आ जाएगा आपको अभी. पब्लिक कंपनी क्या होती है? नंबर 1, इट इज नॉट अ प्राइवेट कंपनी. दैट मीन्स अ कंपनी विच यूजेस द वर्ड लिमिटेड आफ्टर इट्स नेम. दे कैन इनवाइट द पब्लिक फॉर सब्सक्रिप्शंस ऑफ शेयर्स. शेयर्स आर फ्रीली ट्रांसफरेबल. यहाँ पे कोई रिस्ट्रिक्शन नहीं है. प्राइवेट कंपनी में देवर रिस्ट्रिक्शंस, यहाँ पे कोई रिस्ट्रिक्शन नहीं. नो मिनिमम पेड अप कैपिटल. नंबर ऑफ मेंबर्स कितने हैं? वेरी सिंपल, 7 मिनिमम है, मैक्सिमम नो लिमिट. So if I have a public company and I have 50,000 members, can I do it? Yes, ma'am. 50,000 क्या 1 lakh भी ले आओ, हमें कोई फर्क नहीं पड़ता. Public limited company में there is no limit. But can I set up a public company with 5 members? No. Answer is no. At least minimum 7 are required. Subsidiary of a public company is also a public company. अब मैं समझाती हूँ आपको ये important point. It says, let's take for an example, if there is a company A Limited, ABC Limited, it is a public company and it has a subsidiary CD Private Limited. Now law says if public company has a subsidiary, then even if my subsidiary is a private limited company, because it is subsidiary of public company, therefore CD Private Limited shall deem to be a what? Deemed to be a public company. If you are Indian, your children will also be Indian, even if they are influenced by the Western culture. And if my kids tell me that I want to be, I am a US citizen, can it happen? It will say your parents are Indian, you're also Indian. Similarly, if your holding company is a public company, then even if you are a private limited company, you will deem to be considered as a public company. Why? Because you are a subsidiary of a public company. Ma'am, what is holding? What is subsidiary? You have to stay tuned till the next lecture because time is already up. So we'll talk about holding and subsidiary. Abhi ke liye kitna yaad rakhna hai? Public company, minimum 7 members, no limit on the maximum one, no minimum paid up capital. And now what about the subsidiary? Even if you are a private limited company by your articles, means your articles tell you that you are CD private limited. But because I am ABC limited controlling you, then you will be deemed to be a public company. Simple. समझ आ गया? इतनी information पढ़कर आनी है, revise कर आनी है, and let's quickly go through the MCQs. I don't want to leave that. So these are the smaller notes which are given over here. Restrictions, you can simply remember from my notes also. These are just the briefing that we have taken from the study material itself. Controlling the composition of board of directors. This is something which we have not done. Holding and subsidiary, we'll be starting in the next class. Quickly send me the answers for this one. Maximum number of members under a private company. I'm not going to ask you because I've already asked you. Answer is 200. Minimum number of members in a private and public company. Send me the answers immediately. I'm going through your queries. So good children, we try to make the session interactive and I hope you all have enjoyed learning it this way. And though I was very glad to receive the replies instantly from your side. That's nice. Sumit Mahor, Thursday we have the last class. Definitely go through that Narendra Kumar case as well, where you have learned that the guarantors were at the benefit and the shareholders had to pay the money. So that was another interesting thing that we did. Shashank Rai, please send your queries once again. You can send it because they have got mixed up. There are around 6,000-7,000 contents which have gone up. So it's very difficult to find. You can send your queries again. Priyanka, you were already doing the quiz. So those who are answering me the fifth one, please send your answers. Okay. Yes, Abdul, when the corporate veil is lifted, they become one. Good, Nikhil, I'm glad. Kaushik, that's correct. Dinesh, that's correct. Mansi, Mayur, all of you are correct. Definitely, Santosh Kumar, you'll get all the notes. Rudraksh, you only have to remember that only you can be a nominee in one OPC, not more than that. And you can be a nominee in one OPC or you can form one OPC. 2 and 7 is the correct answer. Almost everyone has given the correct answer. So now, by now, you all know we have done n number of examples also. तो ये तो आता ही था आपको. ये मैंने अभी आपको कराया नहीं है. Significant influence. Any guesses? What is the meaning of significant influence? How much is the total percentage share capital or business decisions? Can anyone answer me the sixth one? So, Priyanka Jha, you are expecting me to go to the first page and read that question of nominee of bank. You should have written the question itself. Pushpa, you'll be able to see the partnership notes. I don't know why you're not able to see. I will just get it checked at the back end, why it's not visible. Yes, Aditya Sana, we will definitely look to the parent company first. Dinesh, you can write the sections, but only that you should make sure that you can write the correct section. Yes, definitely section 2. If you're writing, you're not mentioning the clause, then also it's okay. Okay, Shashank Rai, I found your query. If B had a quarrel with A and he suddenly withdrew his name from nominee, is there any time to be provided? So law is silent about time. Did we discuss any time period? What was written? You can just withdraw your consent. No time period is given. No, why will you have OPC without nominee? You have to change the name of the nominee and get it registered there. Karishma, what is subsidiary? You'll come to know in the next class. We have not yet done it. Let me see how many of you answered this one correct. Aditya Sinha, don't worry. We'll try to revise everything on Thursday itself. Vinita Sharma is asking about 120 days. So children, you simply have to remember in case of OPC, I think let's close this. You yet to do it. 20% was the correct answer. Khushi, you have given correct. Sarthak Agarwal, all of you, those have given the correct answers. Okay, children, in OPC, who can open an OPC? 3 points you have to remember. Number one, he should be a natural person. Natural person means, जैसे एक बच्चे ने बड़ा अच्छा लिखा था, somebody who can breathe. So somebody you normal persons, normal human beings, living things. ठीक है? Living things, plants भी होते हैं, but plants cannot open an OPC. So on a lighter note, individuals like you and me, we can open an OPC. कहने का मतलब ये कि company जो artificial person है वो OPC नहीं खोल सकती. Number two, we should be an Indian citizen. We explained Miss A, a foreigner who came, was not allowed to open OPC. Number three, the person should be a resident in India. Now, who is resident in India is actually covered under your income tax provisions. When you will study in CA Inter about income tax, you learn a lot about resident, non-residents. But अभी के लिए OPC के लिए हमें सिर्फ इतना याद रखना है कि who is a resident? The person who has stayed in India for more than 120 days. So he defines it in the different way that not less than 120 days means at least 120 or more than 120 days. If you have stayed in India, then you will be considered as a person who is resident in India. Okay. So if you have stayed in India for 119 days, can you open an OPC? The answer is no. So minimum condition 120 days has to be seen. So these kind of questions like a descriptive case studies can come to you. Yes, Digambar Sahu, that can happen. The company can have the company limited by shares and guarantee, both can be there. Yes, Tynish, it was an associate company, which we'll be covering in the next class. Paid up share capital, Mayur Gupta, yes, it's a small company. But if your turnover is exceeding, you have to see and or. If and is there, both the conditions have to be seen. If any provision is having or, then one of the conditions needs to be fulfilled. Yes, that's correct, Priyanka Jha. Obviously, all the properties will come to the nominee, whosoever is named in the will. Shashank Rai, there is no specific time periods to be mentioned. Please read your study material once again. I just corrected you right now also. Yes, we have to learn the new amendment of 120 days. All right. Samyak Jain, your question is not clear. The sixth one, it was 20%. He's asking the answer for the sixth one. It is 20%, which is an associate companies, which we'll be covering in the next session. So children, your homework for till the next session is revise all the types of companies that we have done today. Even if any query is unanswered, we'll try to take up in the next class. And I'm 100% sure you won't have any queries for this till this much. And subsidiary company and holding company se ghabrana nahi hai. Humne abhi kara nahi hai. We'll be covering up it in the next session. So we'll try to wind up the next session in 1.5 hours. And the balance half an hour, we'll try to keep up for the queries. All right. So try to revise your content. Thank you so much. It was very nice to make a session interactive with you. And I really enjoyed reading out your answers back. And if you have any queries, you can come back to me once again for the next class, which is our last class on Thursday. All right. Goodbye. Take care and revise your work. Thank you.